This is a CBS News special report. I'm Norah O'Donnell here in Washington, and we are coming on the air as special counsel Jack Smith is delivering remarks on the indictment of former President Donald Trump any moment from now. Just over an hour and a half ago, the 38-count indictment was unsealed, 37 of them specifically targeting Mr. Trump. And the accusations made in this indictment are stunning. They allege that the National Archives repeatedly demanded that the former president turn over classified documents beginning in May of 2021. The charges against the former president include willful retention of national defense information, conspiracy to obstruct justice, withholding a document or record, corruptly concealing a document or record, and concealing a document in a federal investigation, scheme to conceal, and false statements and representation.
Hey, so the White House is in full panic mode right now, and I mean absolute chaos behind closed doors, because a federal judge just refused to back down from what could become the most explosive constitutional confrontation in modern American history. We're talking about a sitting cabinet secretary potentially facing criminal contempt charges. We're talking about the Trump administration literally rushing to appeals courts in desperation, begging judges to shut down proceedings that could expose exactly how this White House operates when it thinks nobody's watching. And here's what makes this so much bigger than just another courtroom drama. About whether the President of the United States and his top officials can simply ignore federal court orders whenever they feel like it and face zero consequences. This is about whether the rule of law still means anything in America. And right now, as we speak, that question is being tested in real time. Let me be clear about what just happened, because the mainstream media isn't giving you the full picture. A federal appeals court had to step in at the last minute, literally hours before scheduled hearings, to temporarily pause what Judge James Boasberg had planned. We're talking about live testimony under oath. We're talking about whistleblowers ready to expose what really happened in those meetings where senior administration officials allegedly discussed telling the courts, and I'm quoting directly from Swartz, telling the courts to go pound sand. This isn't speculation. This isn't partisan spin. This is based on actual whistleblower complaints, actual court filings, and actual declarations submitted under penalty of perjury. And the Trump administration is so terrified of what might come out that they're throwing every legal weapon they have at this judge to make him stop asking questions. Now, before we go any further, I need to say something important. You can't really trust mainstream media anymore to tell you the whole story. They'll give you the headline, sure, but won't connect the dots. Won't explain why this matters for every single American, regardless of your politics. That's why we built this channel, to bring you real stories, real context, and no corporate spin. We dig into the court documents. We read the actual filings. We explain what these legal battles actually mean for the future of this country. If you want to stay ahead of the headlines, make sure you subscribe to the channel right now. We bring the news straight to you every single day. Just hit the subscribe button below to join us. And if you want to support this work and be part of a community that truly cares about the truth, this is your moment. Subscribe, leave a comment telling us what you think about what's happening to our courts, to our system of checks and balances. All right, let's get back to the video. Here's what happened. This whole saga traces back to March 5th, 10th, 2025, when the Trump administration invoked something called the Alien Enemies Act, an 18th century wartime law that has almost never been used in peacetime to deport over 200 Venezuelan men to El Salvador. Now, understand what this law was designed for. Written in 1798. When the young American Republic was genuinely worried about foreign invasions during actual declared wars, it gives the president extraordinary powers to round up and remove citizens of enemy nations without the normal due process protections that immigrants would otherwise receive. But here's the thing. There's no declared war with Venezuela. There's no formal conflict. The Trump administration is using a wartime statute during peacetime, arguing that Venezuelan gangs constitute some kind of invasion force that justifies emergency powers. Federal Judge James Boasberg, who serves as chief judge of the U.S. District Court for the District of Columbia, was hearing a challenge to this use of the Alien Enemies Act. During a hearing on that March 5th, 10th date, he issued an order. He told the government to halt the deportation flights. He told them that the planes needed to be turned around. He wanted 14 days to properly consider the constitutional questions at stake. That seems reasonable, right? A federal judge says, hold on, let me review whether what you're doing is legal. And government is supposed to comply with that order while the legal questions get sorted out. That's how the American system of government is supposed to work. The executive branch doesn't just get to ignore the judicial branch whenever it finds a court order inconvenient. Happened instead. Those planes kept flying. Those deportees landed in El Salvador. El Salvador's president, Nayib Bukele, actually posted on social media, and I wish I was making this up, He posted the word oopsie above a news article about Boasberg's order. He was essentially mocking a federal judge's order in real time while the United States government was defying it. And the dust settled, over 200 men were sitting in C. El Salvador's notorious mega prison, despite a federal judge's explicit instructions that they should not be removed from U.S. custody. Now, the Trump administration's defense here has evolved over time, and it's worth tracking exactly how their story has shifted. Initially, they claimed the planes were already in the air when the order came down, so technically those deportees had already left U.S. jurisdiction. But that explanation has some serious problems. For one thing, there's evidence suggesting that at least one flight departed after the judge's oral instructions during the hearing. Another, the administration's own lawyers were in the courtroom when Boasberg gave those instructions. They heard him say to turn the planes around. According to whistleblower complaints filed by a former Justice Department lawyer named Ares Rubin, there were meetings the day before, on March 14th, where senior officials discussed what to do if a judge tried to stop them. According to Reveni's account, a top Justice Department official named Emil Bove allegedly told lawyers that the DOJ would need to consider telling the courts, and again I'm quoting the whistleblower complaint, telling them to go perform an anatomically impossible act on themselves and ignore any such court order. The administration denies this characterization. Emil Bove is no longer with the administration, so he hasn't provided his own declaration. But here's what we do know from actual court filings. Homeland Security Secretary Kristi Noem has now been identified in sworn declarations filed by the Justice Department itself as the official who gave the order to continue the deportation flights after being briefed on Judge Boasberg's directive. Let me say that again so it sinks in. Secretary of Homeland Security, a cabinet member, allegedly ordered the continuation of deportation flights after she was told that a federal judge had ordered those flights stopped. And she did this based on legal advice from Justice Department lawyers and the acting general counsel for DHS. Now, you might be thinking, okay, so there's a dispute about court orders and timing and legal interpretations. That's what appeals courts are for, right? And you would be correct. The Trump administration did appeal, and eventually the Supreme Court ruled that Judge Boasberg didn't actually have jurisdiction over the Alien Enemies Act deportations. The administration won that particular legal fight, but here's where things get really interesting. Really important for understanding what's at stake. Judge Boasberg has determined that the Supreme Court's jurisdictional ruling doesn't cancel out his concern about whether his orders were intentionally defied. Even if a court order turns out to be wrong on appeal, parties are supposed to comply with it while seeking that appeal. You don't just get to ignore judges because you think you'll eventually win on appeal. That's not how the rule of law works. Then every court order would be essentially optional, because anyone could just say, well, I think I'll win on appeal eventually, so I'm not going to comply right now. So Judge Boasberg initiated contempt proceedings. Like in April, he issued what's called a finding of probable cause, which means he determined there was enough evidence to believe the Trump administration had violated his order and that this violation might have been willful. He gave the government opportunities to purge the contempt, which basically means comply with the original order by returning the deportees to U.S. custody. The government didn't do that. The men are still in El Salvador. Still in that mega prison. And so Boasberg has been trying to figure out who exactly made the decision to defy his order and whether that defiance was intentional. This is where the constitutional crisis really starts to take shape. Over the past several weeks, Judge Boasberg has been demanding information. He's been asking for declarations from administration officials. He's been trying to establish who knew what, when they knew it, and why they made the decisions they made. And the administration has been providing as little information as possible while simultaneously arguing that the judge has no authority to even ask questions. Last week, the Justice Department filed declarations from several officials. Secretary Noem filed a declaration saying she was the decision maker and she acted based on legal advice. But she didn't provide the details Boasberg wanted about the substance of that advice or her reasoning. Deputy Attorney General Todd Blanche and Homeland Security General Counsel Joseph Mazzara filed declarations saying they provided legal advice but declining to reveal what that advice was, claiming attorney-client privilege. And the Justice Department's lawyer, a man named Tiberius Davis, essentially dared Judge Boasberg to either make a contempt referral or drop the whole thing. He said the administration has provided all the information it's willing to share. And if that's not good enough for the judge, then he should go ahead and make his referral. But Boasberg wasn't satisfied. He determined that Secretary Noem's declaration didn't provide enough information for him to conclude whether her decision constituted a willful violation of his order. Criminal contempt requires proving that the order was clear and reasonably specific, that the defendant violated the order, and that the violation was willful. Without more information about what Noem knew and why she made the decisions she made, Boasberg couldn't make those determinations. So he scheduled hearings. He ordered testimony from two key witnesses, Drew Ensign, a deputy assistant attorney general who was the government's lawyer in the courtroom on March 10th, and who conveyed the judge's orders to DHS and DOJ leadership, and Erez Ruveni, the former Justice Department lawyer whose whistleblower complaint alleged that senior officials discussed ignoring court orders. The administration went ballistic Friday, December 12th, the Justice Department rushed to the D.C. Circuit Court of Appeals, begging the judges to shut down Boasberg's hearings. I do mean rushed. The hearings were scheduled to begin Monday the 15th, and the administration was filing emergency motions on Friday afternoon trying to stop them. The Justice Department's filing was extraordinary in its rhetoric. They accused Judge Boasberg of engaging in a pattern of retaliation and harassment. They said he has developed too strong a bias to preside over this matter impartially. They asked the appeals court not just to halt the hearings, but to remove Boasberg from the case entirely. They argued that his contempt inquiry exceeds his authority and intrudes on the prerogatives of a co-equal branch of government. Think about what that argument means. The executive branch is essentially saying that the judicial branch has no power to investigate whether the executive branch violated court orders. They're saying that criminal contempt is a criminal offense, and the investigation and prosecution of crimes is a core executive power reserved to the executive branch. In other words, only the Justice Department can decide whether to prosecute anyone for contempt. And since the Justice Department reports to the president's own people will never be prosecuted for defying the president's wishes. It's circular logic that would make the executive branch completely immune from judicial enforcement of court orders. The appeals court ruled late on Friday. A divided three-judge panel voted 2-1 to issue a temporary stay of the hearings. Judges Niami Rowe and Justin Walker, both appointed by Trump during his first term, voted to pause the proceedings. Judge Michelle Childs, appointed by Biden, would have denied the stay. The majority emphasized that the stay is temporary and should not be construed as a ruling on the merits. They said they need more time to consider the issue. For now, hearings are on hold. Here's where this gets even more dramatic. This entire fight with Judge Boasberg is taking place against a backdrop of unprecedented hostility between the Trump administration and the federal judiciary. Trump himself has called for Boasberg to be impeached. Back in March, when Boasberg first issued his order halting the deportation flights, Trump posted on social media calling him a radical left lunatic, a troublemaker and agitator. He mocked the very idea that a federal judge could constrain his actions as president, writing that Boasberg didn't win the popular vote. And he said, and I'm quoting directly, "This judge, like many of the crooked judges I'm forced to appear before, should be impeached." That prompted a rare public statement from Chief Justice John Roberts, who almost never comments on political matters. Roberts wrote that for more than 2 centuries, it has been established that impeachment is not an appropriate response to disagreement concerning a judicial decision. The normal appellate review process exists for that purpose. It was a direct rebuke of the president by the nation's top judge. A remarkable moment in American constitutional history. But the impeachment threats haven't stopped. Republican Representative Brandon Gill of Texas has introduced articles of impeachment against Boasberg, first in March over the deportation ruling, and again in November when it emerged that Boasberg had signed off on subpoenas and non-disclosure orders as part of former special counsel Jack Smith's investigation into Trump. That investigation, codenamed Arctic Frost, reportedly sought phone records from Republican senators. And Republicans have accused Boasberg of being an accomplice in what they call an egregious scandal. The articles of impeachment have multiple Senator Ted Cruz has called for the House to impeach Boasberg, calling him a partisan left-wing activist who needs to be removed from office. There's even been a Senate hearing about it. Senate Judiciary Subcommittee held a hearing in early December titled Impeachment, holding rogue judges accountable. The very framing of that hearing tells you everything about where Republican leadership stands. They're calling federal judges who rule against the administration rogues who need to be held accountable. They're treating unfavorable court rulings not as legitimate exercises of judicial review, but as illegitimate acts of partisan warfare. And this isn't just about Boasberg. Republicans have filed impeachment resolutions against at least 5 federal judges this year, all of them for issuing rulings unfavorable to the Trump administration. They've targeted judges who blocked immigration policies, judges who ruled against funding decisions, judges who challenged executive actions on various fronts. It's a systematic campaign to intimidate the judiciary into compliance with the administration's wishes. Federal judges themselves are speaking out in ways they almost never do. A report from NPR described judges publicly warning about threats they face this year after ruling against the Trump administration. Judge Jack McConnell, chief judge for the District of Rhode Island, has spoken about the hostile environment. Judge Robert Lasnik in Seattle received pizza deliveries at his home after speaking to media, with the implicit message being, know where you live. Judge John Coffiner in Washington state experienced what's called swatting, where someone called the local sheriff claiming he had murdered his wife, resulting in armed officers arriving at his home. Judge Esther Salas in New Jersey, who 5 years ago had her son murdered by a disgruntled lawyer who showed up at her home, organized a forum to draw attention to threats against judges, noting that people are sending unwanted pizzas to judges using her dead son's name. Yuan San. Marshal's Service, which is responsible for protecting federal judges, told NPR that protecting the judiciary remains a top priority. but they're already busy chasing leads on threats against dozens of sitting federal judges, many of them following rulings against the Trump administration. A White House spokesman told NPR that attacks against public officials, including judges, have no place in our society. But that statement rings hollow when the president himself is calling for judges to be impeached, and his allies are filing the impeachment resolutions to back up those threats. Okay, let's break down what this actually means, because this is so much bigger than just one case or one judge. First, understand that this is about the fundamental architecture of American government. The Constitution creates three co-equal branches: the legislative branch that makes laws, executive branch that enforces laws, judicial branch that interprets laws and resolves disputes. The system only works if each branch respects the authority of the others. When the executive branch decides it can simply ignore judicial orders whenever it finds them inconvenient, the entire system breaks down. Courts have no army. They can't force compliance at the barrel of a gun. Their power depends entirely on the principle that their orders will be obeyed. That the executive branch will enforce court judgments even when those judgments go against the executive branch's own preferences. That principle is being tested right now in the most direct way possible. Second, consider what it means for the contempt power specifically. The ability of courts to hold people in contempt is essential to the functioning of the judicial system. If parties could simply ignore court orders with no consequences, then courts would be powerless. Why would anyone comply with a ruling they don't like if defiance carries no penalty? The Trump administration is essentially arguing that when it comes to executive branch officials, courts have no effective contempt power because only the executive branch can prosecute contempt, and the executive branch will never prosecute its own people for following the president's wish. A recipe for complete executive impunity. Third, think about the precedent this set. The Trump administration can ignore Judge Boasberg's orders with no consequences. What's to stop any future administration from doing the same? What's to stop a Democratic president from ignoring court orders on abortion or gun rights or religious liberty or any other issue where a conservative judge rules against them? The rule of law either applies to everyone or it applies to no one. Every time we make an exception for our side because we agree with the policy outcome, weakening the principle that will protect us when we disagree with the next nation's policies. Fourth, consider the specific context of immigration enforcement. The Alien Enemies Act is a wartime statute being used in peacetime. The administration is arguing that Venezuelan gangs constitute an invasion force that justifies emergency powers. But that's an extraordinary claim. If the president can declare that any criminal organization from a foreign country constitutes an invasion, thereby triggering wartime authorities, then there's essentially no limit on executive power. Every drug cartel, every foreign gang, every criminal network with international connections could potentially be used to justify emergency deportation powers that bypass normal due process. And if courts can't review these determinations, or if their review can simply be ignored, then the safeguards we have against government overreach become meaningless. Fifth, look at what's happening with presidential immunity more broadly. Last year, the Supreme Court ruled in Trump v. United States that presidents have broad immunity from criminal prosecution for official acts. That decision has been enormously consequential. It delayed and ultimately derailed the federal prosecution of Trump for his alleged role in January 6th and the attempt to overturn the 2020 election. It's being invoked in other contexts now, including to shield administration officials involved in controversial military strikes against suspected drug boats in the Caribbean that have killed dozens of people. The administration is even demanding that the International Criminal Court amend its founding document to guarantee that it won't prosecute Trump or other administration officials. They're threatening sanctions against ICC judges if the court doesn't comply. We're watching the construction of an imperial presidency in real time. Between the immunity ruling and the refusal to comply with court orders and the impeachment threats against judges and the dismantling of independent agencies and the removal of inspectors general and the firing of the special counsel and the gutting of the Merit Systems Protection Board, every institutional check on presidential power is being systematically neutralized. The Boasberg contempt case is one of the last remaining fronts where anyone is even trying to hold the line. Sixth, consider the political dimensions. The 2026 midterm elections are approaching. How this constitutional crisis plays out could have enormous electoral consequences. If the administration is seen as lawlessly defying courts and getting away with it, that energizes one base while outraging another. Boasberg successfully refers officials for contempt prosecution, even if the Justice Department refuses to prosecute. That creates a narrative of executive lawlessness that Democrats will hammer in campaign ads. The administration successfully removes Boasberg from the case or gets his contempt inquiry permanently shut down. That's a win for Trump, but it could also motivate voters who are concerned about Democratic backsliding Republicans in the Senate have been notably cautious about the impeachment push. Senior senators like John Cornyn and Lisa Murkowski have warned that they won't vote to convict judges simply for issuing rulings the administration doesn't like. Cornyn called the impeachment effort a fantasy, noting that you need 2/3 of the Senate to convict and remove a judge, which means you'd need 14 Democrats to go along. That's not happening. Murkowski said they can't be impeaching every judge they don't like the decisions of. The threats of impeachment are politically useful for rallying the base, but actually removing judges through impeachment would require a level of Senate support that doesn't exist. Seventh, watch what happens next with the D.C. Circuit. The appeals court issued a temporary stay, but they're still considering the merits of the administration's arguments. They rule for the administration and shut down Boasberg's contempt inquiry entirely. That would be a massive victory for executive power and a devastating blow to judicial authority. If they rule against the administration and let the hearings proceed, we'll see actual testimony under oath about what happened on March 5th, who made what decisions and why, and whether senior officials really did discuss ignoring court orders. Either outcome will be historic. Eighth, consider the international implications. America's allies are watching this. Our credibility as a nation governed by law, as a nation where even the most powerful officials are accountable to the courts, is part of what gives us moral authority in the world. When we lecture other countries about rule of law and judicial independence, they can point to what's happening here. How can we criticize authoritarian regimes for defying their courts when our own administration is doing the same? How can we promote democratic values abroad when democratic norms are being eroded at home? The markets are watching too. One of the things that makes America attractive for international investment is the stability and predictability of our legal system. Investors know that contracts will be enforced, that disputes will be resolved fairly by independent courts, that the government can't just take your property or void your agreements on a whim. When the executive branch demonstrates that it will defy court orders when it finds them inconvenient, that uncertainty seeps into everything. It's not just about immigration or executive power. It's about whether the basic legal infrastructure of American commerce remains reliable. Our adversaries are watching most closely of all. Russia, China, Iran, they all benefit when America looks like a nation and constitutional. They benefit when we're distracted by internal legal battles instead of focused on external threats. They benefit when our moral authority is diminished by our own government's apparent disregard for the rule of law. Every time Trump attacks a judge or Republicans file impeachment articles against jurists who rule against the administration, it's content for foreign propaganda operations that want to portray American democracy as hypocritical and failing. So here's the bottom line. What's happening right now with Judge Boasberg isn't just a legal dispute about immigration enforcement or deportation flights or the Alien Enemies Act. Test of whether the American system of checks and balances still functions. It's a test of whether federal courts can hold the executive branch accountable. It's a test of whether the rule of law applies to everyone or whether those in power can simply opt out when compliance becomes inconvenient. The appeals court has temporarily paused the contempt hearings, but this story is far from over. The D.C. Circuit still has to rule on the merits of the arguments. If those hearings eventually happen, we'll hear testimony from witnesses who were in the room when these decisions were made. We'll get answers under oath about whether senior administration officials really did discuss ignoring court orders as a matter of policy, and Judge Boasberg will have to decide whether to refer anyone for criminal contempt prosecution. Full well that the Justice Department he'd be referring to is controlled by the very people who might be the targets of that referral. The administration is betting that they can run out the clock, that they can obstruct an appeal until the whole thing fizzles out. Tension moves on to the next crisis. They might be right. The American public has limited bandwidth for constitutional controversies, and there's always something new to be outraged about. This one matters. This one goes to the heart of what kind of country we are. Because if the executive branch can simply ignore the judicial branch whenever it wants, then we don't have 3 co-equal branches of government anymore. We have 1 branch with all the power and 2 branches with fancy titles and no teeth. Keep your eyes on this case. Watch what the D.C. Circuit decides. Watch whether the hearings eventually happen. Watch whether anyone faces actual consequences for what appears to be deliberate defiance of a federal court order. And ask yourself, if this administration can get away with ignoring judges today, what will the next administration get away with tomorrow? The precedent being set right now will shape American governance for decades to come. This isn't just about Trump and Boasberg. This is about whether the Constitution means what it says, whether power has limits, whether anyone in this country is truly above the law. And right now, in real time, we're finding out the answer. The story is evolving rapidly. A temporary stay from the D.C. Circuit could be lifted at any time. The appeals court could rule on the merits within days or weeks. And the broader conflict between the Trump administration and the federal judiciary shows no signs of cooling down. Dozens of other cases working through the courts, dozens of other judges being threatened with impeachment, dozens of other institutional battles being fought on multiple fronts. What happens with Boasberg will influence all of them. A victory for executive defiance here will embolden the administration in all those other fights. A defeat will at least create some pause, some reminder that courts still have power, that the Constitution still constrains the president even when he doesn't want it to. We'll be watching every development and bringing you the analysis you need to understand what it all means, as this matters. This matters more than almost anything else happening in American politics right now. The future of our system of government is being decided not in some abstract theoretical sense, but in actual courtrooms, in actual filings, in actual confrontations between judges and the executive branch, and every American should be paying attention. Watching, make sure you subscribe so you don't miss our coverage as this story continues to unfold. Share this video with anyone who needs to understand what's really happening to the rule of law. Stay vigilant, because the price of liberty, say, is eternal vigilance. And right now, liberty needs all the vigilance we can muster.